The Canine and Feline Behaviour Association employs Britain's top seminar experts for your professional development. Seminars are exciting and stimulate new and modern ideas from Britain's top experts.
Thank you very, very much for coming here today to have this input on dangerous dog law unleashed. I'm Colin Spender, and Dr. Simon Harding, who is sat in the chair just behind, who will be coming up later on to do his part about dog law unleashed. And for myself, my colleague and other colleagues in the police service, sometimes for us it can be very difficult because we're the ones that have to pick up the pieces at the end of the day when things go wrong and when dogs have to be put to sleep. And quite often, owners come back to us and ask us to take that responsibility. So we're the ones that have to be present whilst the dog's put to sleep. So emotionally for us, it's quite draining. Some people don't see that out on the streets. They think that all police officers are out there just to have these dogs put to sleep. That's not the case. If we can do what we can to enable the dog to go back to the owner, fine. If it's a dog that can't go back for one reason or another, or they're too dangerous, then at the end of the day, we've got to think about the needs of that dog. And quite often, for those sort of dogs, there is no choice. The dog has to be put to sleep. Speaking to lots of people, dog owners, they do not know a lot about the law. And unfortunately, they put themselves in positions whereby it makes it difficult for us as police officers and you as owners and us as dog trainers and behaviourists. So having some knowledge about your roles and responsibilities as dog owners is a good thing, because then it stops you getting into trouble. This dog is called Honey. It's one of the dogs that we've dealt with back in our force. Fortunately, she has gone back to her owner under what we call a 4B, continued destruction. And it's about leashes, muzzles, and having the dog tattooed and all the rest of it, but we will cover that later on this afternoon. Right, who owns a dog? It's very, very difficult. Yes, lots of us own dogs, but we do find for us as in the police service, and as will be discussed later on, there are lots of dogs out in society that aren't technically owned by people. They become what are called pool dogs. It's like a pool vehicle. Criminals, when they use a vehicle, nobody owns the vehicle. It just gets passed on from person to person to person. So there is no particular owner for that dog until it comes to the point where somebody has to admit ownership. And it's the same for dogs. And again, as it says, there's no single document or other piece of evidence which conclusively proves who owns a dog. You could have kennel club registration. The dog could be tattooed or microchip in your name. You could have a sales receipt, insurance certificate, and veterinary records. At the end of the day, primarily, it's the person that takes responsibility for that dog, the primary carer. The person that has primary care of that dog normally is the person that has ownership of the dog. And it's an important word, ownership, because we will be discussing it under legislation. Because even by owning the dog, if you don't necessarily own the dog but keep the dog, you can be committing offences under the legislation. So it's important to understand the difference between ownership and keeper. When it comes to dog law and law legislation, it's those little words that make all the difference. The and, the ors and the buts. And a lot of it is about interpretation of what that law says. What we're going to be looking at particularly today is the Animals Act of 1971, the Dangerous Dogs Act 1991, as amended in 1997, and that came in as a result of all the dogs being destroyed, the dangerous dog, the banned breed dogs, back in 1991. And it was decided that it was wrong to have all these dogs put to sleep, hence we had the Amendment Act come in 1997. Dogs Act of 1871, which is the civil side of it rather than the criminal. Metropolitan Police Act, Town Police Clauses, Offences Against the Person, Occupiers Liability Act. I've had to reduce the input down because I don't want to overload you with too much law and legislation. If we're fortunate enough to get through, there is some more that I can give you in relation to the Environmental Act, EPO and all the rest of it. Canis familiaris, we all know what that is, don't we? Are dogs. And again, I've given you a picture of a dog in its natural form, the bone, because that's what we have to deal with at the end of the day, the dog, irrespective of breed, size, shape. They're all the same thing at the end of the day. Canis familiaris, the family pet dog. Right, the Dogs Act 1871. Is there anybody here that's, I know there is one person that's into law itself, but is there anybody here that's heavily involved in the law legislation? In fact, I know there's 2 people here that are in the sort of law field of it. No volunteers? So I'm not going to have a debate at all with, with anyone. Right, the Dogs Act of 1871. This is civil law, not criminal. Section 2 of the Dogs Act 1871 is the only bit that was kept from that legislation. This part of the legislation makes it fair for everybody. So, under the Dogs Act of 1871, if it appears a dog is dangerous, dangerous we have to take in the context of its normal meaning, what is and what isn't dangerous. And normally it's for the magistrates to decide what is and what isn't a dangerous dog. Courts may make an order directing that the dog is kept under proper control or destroyed. This is under the civil legislation, and the magistrates still have the power to do that. So it's a summary jurisdiction. It's done in front of a magistrates court. And when the court are looking at that evidence, they're looking at the general disposition of the dog in that particular instance, or the antecedents of the dog. If the dog's got previous history as regards what it has done or is alleged that it's done, for it to be put in front of the courts. And the courts can consider character evidence from the behaviourist, vets, neighbours, families, friends. They can take this all into consideration before the courts make a decision as to what should or should not happen to that dog. So if a dog's found to be dangerous, magistrates can make an order, and it's their discretion to impose a control order or have the dog destroyed. The owner can make an appeal against the control order or destruction order, and it normally goes up through to the Crown Court for the Crown Court's judge to make a decision as to whether or not the dog will have a control order put on it, or whether the dog should be destroyed or not. Under the DDA of 1989, section 1.2, this reinforces the legislation under the civil law, which gives the magistrates the power to put a destruction order on the dog. And as you can see, there was a High Court ruling under the Queen's Bench Division of Briscoe and Shattuck that held that a dog could be considered to be dangerous and not under proper control when the only danger shown was to other dogs, not just to humans. And this is where section 2 of the Dogs Act 1871 comes in. So there is a stated case, or there is stated cases that says it doesn't have to be directed just at the person.
CFBA venues are the best in Britain, air-conditioned and modern. We offer coffee, tea and light refreshments at all seminars. Seminar seats are booked rapidly, so do ensure your reservation online today.